Hello, good evening and welcome to NDTV. This is Breaking Views. I am Ankit Tyagi. Ladies and gentlemen, today was the sixth day or the sixth hearing as far as the Supreme Court's historic hearing on the same-sex marriage is going on. Some very interesting, in fact, arguments and counter-arguments, questions and discussions took place in the court number 1, the constitutional bench, which is led by CJI, Mr. Chandrachud. Now, key questions today was asked, and that key question is, how can same-sex couples avail social benefits? This is what the court today asked of the government. In certain things, the government also, or at least represented by the Solicitor General, did agree that, all these questions of benefits as far as the same-sex couples are concerned, they need to be looked upon, they need to be looked in further detail. But the centre kept coming up with their arguments, sometimes using notions of incest and others to try and dissuade the court in thinking towards any sort of ruling as far as in favour of the same-sex marriage is concerned. Now, remember, this hearing is going on a clutch of petitions which have been filed in the Supreme Court. The Supreme Court is hearing it like it heard the Ayodhya matter. The Constitution bench at this moment looking at the validity of this question. Now, let's very quickly, in fact, as I told you, dozens of same-sex couples had approached the Supreme Court. Now, let's first, in fact, go ahead and talk about what happened as far as the Supreme Court is concerned today. What were the arguments that were made by the various parties in the court today? In fact, the court asked, how can same-sex couple avail social benefits? This is what the top question the Supreme Court has put to the centre. Now, the Supreme Court has also asked the government, see how to address issues without granting marital status. Because this has been one argument which has been put forward by the same-sex couples, that despite the decriminalization of Section 377 of the IPC, they cannot nominate their partner as far whether it's their bank account or their insurance, like any heterosexual couple can. Now, apart from that, the CJI also said, agreed that if the arena of legislature, now what? The CJI said, what does the government want to do with the cohabitatory relations? The Supreme Court seeks centre's response on Wednesday on all these issues. So there have been, and as the Supreme Court has made these changes, you can hear these arguments live, fascinating arguments that go in the court. Let's just listen in to some of the highlights today in this case that took place inside the court number 1 of the Supreme Court.
That I am attracted to my sister. I get, we are consenting adults. We are entering into activities within the privacy, and we claim our right of autonomy, our right of choice, and our right of doing something in private domain. Based on that very argument, my lord, I am posing a question to myself. Can someone not challenge this definition itself? Why this restriction?
But look, if the court were to go into the legislative arena, you've made a very powerful argument on that, look, you'll be legislating. This is not your remit. This is for Parliament or the state legislatures under entry 5, as we put up front. But short of that, our law has gone so far now. Now what does the government want to do to ensure that these cohabitatory relationships, if I can call it that, the relationships based on cohabitation, on association, Brother Narasimha says, they must be recognized in terms of creating conditions of security, social welfare. And to ensure, by doing that, we also ensure that for the future, that these relationships cease to be ostracized in society.
All right, so arguments have been, in fact, going on as far as the Supreme Court is concerned. You heard a few of them where the Solicitor General was making an argument about sexual preferences in the court, of course, asking, counter questions on that. Let's very quickly open this out, because the key question today is, what about the basic rights as far as the same-sex couples is concerned? Let's very quickly introduce my guests, those who are joining me on the broadcast at this moment. We are, in fact, going across to my guest, Mr. Deshratan Nigam, is with us at this moment. He is a lawyer himself, and he will go across and present supports the BJP and also the government's point of view as far as this case is concerned. Geeta Bhatt, political analyst leaning towards the right, is also with us at this moment. We also have Mario de Pena, petitioner for the queer marriages, same-sex marriages, and Rituparna Bora, co-founder of the Nazaria Foundation, is also with us. I welcome all of you to the show. Thank you for joining us on the broadcast. I want to start by asking you, Mr. Deshratan Nigam, very important question today was asked by the Supreme Court. Forget the sanctity of the marriage and whether this court in fact rules anything on it. What about the basic fundamental rights as far as the same-sex couples are concerned, or the LGBTQ community is concerned, whether it is about being nominee or in their insurance scheme and other benefits that heterosexual couples get? The court has given time till Wednesday as far as the government is concerned. What is your view on that, sir?
Ankit, in fact, today the court, as I have always been talking on the TV channels, in fact on NDTV itself, that social marriage recognition is a social status and falls within the domain of the parliament to legislate or not to legislate, and this is what I think the Supreme Court bench is also veering about it. And the next question arises to give them social benefits equal to those of married couples, which means giving the same kind of status to that of married couples, the fundamental rights that the married couples have. And who can give that? So Supreme Court, which it cannot achieve directly, for which it is veering around that it falls in the parliamentary domain, is trying to achieve indirectly. So that's a very important question, and that has to be kept in mind. So equation with the married couples cannot be done. Now, to open a joint account, any two-person can open a joint account. That's not an issue. Nominees, yes, they ask a relationship. So far as insurance is concerned, they ask what is your relationship. And that is where the question of marriage comes. And to
but
give
Mr.
them
fundamental... because let me just ask you a counter question before I move on to my other guest. Argument that only legislature, because this is what the basic premise of the government also is, and you are saying the same thing, that only the legislature alone can rule on this issue. The court is not legislating by hearing these petitions, but ruling on the constitutionality of the laws involved in this question. So why should the court not go ahead and rule on this?
Let me tell you, the constitutionality has not been challenged. Whether these particular act is ultra vires the constitution, that is not before the question. They want it to be interpreted in a manner so that same-sex marriage gets the marital status of that of married couples.
Okay.
And to say that it is unconstitutionality, then you have to decide at least 160 laws, the constitutionality of those that Supreme Court cannot do. They have to change the definition of marriage.
Can the argument that so many laws will have to be amended, can that hold, or can that be the biggest hurdle in terms of progression or reform? I will come to that for you, for a response from you on that. But before I do that, Mario, if I can, bring you in. Today I was going through a piece which has been written by Mr. Swapan Das Gupta, member of parliament of the Bharatiya Janata Party, and also one of very prominent intellectuals as far as the right, center to right position is concerned. He said, and I just want your response on that, and I'm quoting him here. He said that India, it would seem, is being force-fed a fringe view of the new enlightenment. Is that how? What is your response to Mr. Swapan Das Gupta when he says that a fringe is force-feeding their views on the majority?
What I would like to say in response to that is queer people are everywhere and we are not a fringe. If you gave us the right and the dignity to lead our lives, to the fullest sense of what it means to lead a life in this country, not as second-class citizens, not as people who have to beg the court for basic rights that the other panelists on this TV show have. if you don't treat us as second-class citizens, you will realize we are everywhere, and we are a large part of the population. Our census does not ask the basic question of how many of us there are around. So you don't actually know. There have been studies done in other progressive countries where it has been shown that up to 7% of the population now identifies as LGBT. So we aren't a fringe. And I think if you start treating us like a fringe, as second-class citizens, you know what the Solicitor General tried to do in court today by speaking about us with a complete lack of dignity, by saying that we are on the same lines as incestuous people. That is really unfair.
Absolutely.
And it is a way of treating us as second-class citizens and telling the rest of this country that we are nothing better than second-class citizens.
And that distinction has been very clearly made in the 2018 historic judgment by the Supreme Court. Its Supreme Court has not decriminalized, these sections as far as incest is concerned, or rape or anything else. They have only gone ahead and decriminalized or read down the provisions under Section 377. But Geeta Bhatt, I can bring you in. A very important argument was made, and this is what Mr. Swapan Das Gupta, when he said a fringe is force-feeding their view on the majority, but can the majority in any country be left loose to dictate how a minority should live, breathe, and their basic fundamental rights?
Ankit, it is so ironical that the Uniform Civil Code is still date is which is part of the directive principles in the Constitution, is still languishing and yet to see the daylight in terms of judiciary intervening in it, and there is still no constitution bench on it, something which actually is going to influence and affect a large number of women in this country. But nevertheless, but the question that you are asking, you see, the point here is that there are two aspects to it. One aspect is the social aspect, and the other is the aspect in terms of looking in legal terms. The social, if you look at the legal aspect, definitely this is what has been discussed in the court today, that even under Special Marriage Act, if you are trying to make any changes, it cannot be done without affecting the personal laws, because there is a correlation between. There are various provisions within the Special Marriage Act which are directly related to the personal laws, and in that case you cannot say that we are not going to touch the personal laws.
So are we somewhere saying, Geeta Bhatt, that because of all these arguments, the privileges that you get or somebody else who's a heterosexual couple gets about about nominations, all those should be denied? All those basic rights should be denied?
You see, basic rights in terms of, there are single women who get, adoption rights. They adopt babies in this country. It is not that. I know single women who have adopted children. So, see, the point is that if you are talking in terms of protecting their vulnerabilities, there could be, you can discuss in those terms, but in terms of providing, a legal sanctity to marriage, which is sacrosanct, in any personal law.
Ma'am, but okay, I'll come back to this. I'll come back to this. What you're saying is sacrosanct, but Rituparna, the notion that this is exactly where largely the argument that is being drawn, that the notion of same-sex marriage challenges the very institution of marriage, which cuts across almost all religions. The argument is that your demand, or the people, those who are the petitioners in this case, their demand will turn the world upside down.
It will turn the world upside down. Therefore, everyone is actually after us. I would actually remind both Geeta Bhatt and the other speaker that we are the citizens of this country. And the first thing that the Constitution of the country talks about is the preamble. And the preamble talks about the fact that we, the people of India, having solemnly resolved, blah, 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 to secure to all its citizens. And we are regarded as citizens. Some of us pay taxes. we all are entitled to votes, we are also abiding by the rules of this country. And when we are abiding by the rules of this country and we are regarded as citizens, when we are regarded as citizens, we are also to be treated equally. When the Solicitor General again and again in his arguments kept on saying that homosexual people or queer or trans people are not in equal status to us, and when he means us heterosexual people, it is very triggering for us. And what Geeta Bhatt said that single women are adopting. Who is stopping single women from adopting? Not every LGBT people will get married. Some will not get married. It is not a monolithic group, but people who want to get married. Why are we not allowing them to get married? Marriage is such a sacred institution that many parents are forcing their daughters, and actually forcing many marriages in India are still arranged marriages. And when a daughter says that they don't want to get married, they're forcefully getting married at the age of 14 even.
Right.
So when marriage is so sacrosanct, then why isn't a queer or a trans person being allowed to get married? Is my question.
Mr. Deshwardhan Nigam, if I can bring you in, like the argument that you were making earlier, sir. I'm coming to you, ma'am. Many laws have to be amended to make this possible. I mean, can this argument hold against, let's say, social or legal reforms and progress in general?
Well, Ankit, we live in a parliamentary democracy. Any change in law or amendment has to be done by Parliament. This is the short point. Whether Parliament does it tomorrow or not is another question. So, something which has to fall within the parliamentary domain, can Supreme Court enter into it? And that is what the Supreme Court bench is also veering to that very same view. Now, individual rights are not compromised. Here, this community as an individual has all the rights as Ms. Geeta Bhatt has, or me has, or other panelists have. But the status equalizing with that of married couple is the distinction that you have to keep in mind. That because the marriage has been defined in a manner by the acts of the Parliament, the other definitions cannot be brought in by the Supreme Court. Therefore, the Parliament can change this. So, anything that has to happen with the laws, we are in a rule of law, country of rule of law. We are not a banana republic. It has got to go through the Parliament. Parliament has to discuss. And whether who decides what is a reform, the Parliament will decide, the society will decide. 5 judges seated on there cannot decide what is a reform and what is not a reform, because it's a social phenomena. It has got to go through the Parliament. These are very serious, complex questions.
Okay, Rituparna disagrees and vehemently is shaking her head. Before I go to Mario, Rituparna, you want to come in because what Mr. Deshwardhan Nigam essentially says that at this moment, whatever the Parliament is, whatever the court is doing, it's absolutely beyond its purview. So if the government support for the historic 2018 judgment against 377 was possibly a step forward, doesn't this stance of the government to play the arbiter for the LGBTQ community's freedom somehow displays its discomfort with the family relationships?
Okay, so I'm a political science student, and as a student, and I have to say this: we are a democratic country, and therefore the legislature, the judiciary, and the executioner have different roles. The judiciary, the Supreme Court is also known as a guardian of the Constitution. And now, when we as petitioners are asking our constitutional rights, please remember this, we are asking for our constitutional rights. We are asking our rights to be protected. And as the guardian of the Constitution, the Supreme Court has every right to protect our rights.
Okay.
So please, so the legislature can make laws, but as the guardian of the Constitution, the Supreme Court can absolutely give a judgment.
Okay. But Mario, barring a few exceptions, comments which, and I see a lot of people from the petitioners and those who are supporting this cause, they seem to be celebrating the exchange which is going on as far as the court is concerned. Some very valid questions being raised by the CJI and other judges as well. But barring a few exceptions, most of these comments do not make it to the final judgment. Is there somehow, you feel that an attempt to create a discourse by using what is happening as far as the day-to-day hearing is concerned in the court?
See, I would not presume to know what the final judgment of the learned judges is going to be. But I have great faith in our judiciary and in the 5-judge bench of the Supreme Court that will be considering this matter. And I think that the judges are really, giving both parties their due. So I don't think that. It's not fair to presume in one way or the other which way the judgment will go. However, I will say this: the Solicitor General today suggested that some kind of rights may be given. Mr. Deshratan Nigam also suggested that some kind of rights may be given, but the dignity of marriage will be kept away from community. And I just want to say, I'm also a historian. No matter where you've gone in the world, conservative governments first offer a little bit of civil union, a little bit of domestic partnership, but the craving, the desire for the dignity of marriage never subsides. And I think we have to remember that as citizens, because when you offer marriage, you offer something that the other two don't offer.
Absolutely.
Marriage, it is a bouquet of rights, of course, but it is also an issue of dignity, and we should never forget that.
Okay, but Geeta, can tradition be the basis of modern understanding of fundamental rights, or can it be a barrier, as I asked earlier, in legal reforms?
Ankit, if you talk in terms of traditions, then I think in Bharatiya tradition, alternative orientations are always inclusive within the society. Whether it is in terms of, Ardhanarishwar, or whether it is in terms of Tritiya Prakriti. It has always been a part and parcel of the Indian society. They were never discriminated. But here what you are talking of in terms of is putting them, as in the center of the society and trying to redefine what marriage stands for. And also, please do understand, this is going to have ramifications which are going to severely affect the protection which the law has been given to women in this country. Whether it is in terms of Dowry Prohibition Act or whether it is in sexual harassment.
How?
Various laws which are, because you are redefining in terms of, you're trying to redefine in terms of what a man stands for, what a woman stands for. You are trying to redefine what marriage stands for.
No, but why should we only look in that? That's the problem. You are looking at it only from the prism of a man and a woman. We are talking about not just a man and just a woman here.
No, you can't. See, here the question is, you are saying that the Special Marriage Act in the amendment can be brought in the Special Marriage Act.
Okay.
No one is talking about a special act meant for this purpose. No one is talking about
My
that.
response to what Geeta Bhatt is saying, that this is going to open a Pandora box, which will have problems in terms of the legal rights and of course the laws and also in terms of society. Geeta Bhatt, okay, complete in 10 seconds.
You see, petitioners are surely trying to avoid going into personal laws of Muslims and Christians because they very well know that what their holy scriptures, how they stand on this.
Come on, let's not give even this debate, which is of a rainbow color, a specific religious color. Mario, respond to what Geeta Bhatt is saying.
I won't give in to Ms. Bhatt's last provocation, but I will say that our constitution is broad and strong enough to allow equal dignity before the eyes of the law, but also to acknowledge that there are some people within our country who are more marginalized than the others. So it does make special provisions for women. It does make special provisions for the scheduled caste. And this exists at the same time that the Constitution promises equal dignity before the law.
Okay.
So if both of these can be brought together in compromise, I really don't see how our petitions before the court are going to lead to some situation where there is a loss of rights for women.
Okay.
I would like to reassure Ms. Bhatt that there won't be any such thing.
Okay, Yashwardhan Nigam, what about the argument that, same-sex marriage, it doesn't subvert the institution of marriage, but it makes it more inclusive? There are others on the margin, those who can actually avail the same benefits that a heterosexual couple is. So what's the problem with that? They're not asking you to change the way you live your life.
See, again, I'm saying these are social complex issues, cannot be decided in court. If tomorrow Parliament in its wisdom thinks it can be allowed, it can be allowed. The fact is, who decides?
But Yashwardhan Nigam, there have been 10 countries out of 32 which have legalized same-sex marriage. 10 of them, including the United States of America, has done it through the courts. In fact, it has come out through a ruling as far as the courts are concerned. Why not in India?
Let me answer that. We are not a cut, copy, paste kind of a society. We are a society. Our legal jurisprudence are based on our own historical context and the customs and traditions. Theirs is based on theirs.
The basic argument of this law, you find the roots in the colonial law. So it's cut, copy, paste of the colonial morality and that law.
See, the fact is that morality which is there, it has to be tested with ancient Indian scriptures and today's present. And who decides that? Who decides that is an issue. Society will decide through its parliament. These are social reforms you're talking about. Who decides what is a reform?
Okay, I'm completely out of time on this, but it just seems that one step forward in 2018 and 2 steps back today with where the government stands as far as this view is concerned. And it's also becomes quite comfortable to make this argument that Gulami ki zanjeere todo and all those rules and laws which have to change. But when it suits our purpose today, we stick to the colonial era laws which possibly have no relevance today. But thank you so much to all my panelists for joining me and expressing your views on the broadcast. Thank you so much to our viewers for joining us on this edition of Breaking News. News and updates will continue on the other side with my colleague Vishnu Som. Stay tuned.